All Wednesday Lives Matter. Did you see the All Wednesday Lives Matter doll in the back there? Took their fist up. All Wednesday Lives Matter. In Sybil's office in the back.
Mm-hmm. She's chugging.
I love those TikTok videos that say, you're so old, and then they show you everything like from the 70s,
They would call us at night and say, do you know where your kids are?
At 10 o'clock at night, the commercial would come on. Do you know where your kids are?
I like the ones where they catch the little boy smoking pot and he goes, and his dad goes, well, who taught you how to do this? I learned it from watching you.
I don't remember that one.
The Say No to Drugs commercial. There was a little boy that got scared.
I remember the egg. Remember, this is your brain. This is your brain on drugs. And then they would fry the egg on the pan.
Yeah.
1989. 87.
Well, one of the first commercials, it'd always get me when I was a little kid. I'd start to cry. The Indian, he would be with his horse through New York City, and then he'd get to the whole country was polluted and littered. And then they'd show the Indian face and the teardrop coming down his eye. What we were doing to our country, we were polluting it.
That is sad. Mateo always cries when they have the little abandoned abuse.
Oh, the dogs with
orphan,
Sarah.
The dogs.
Oh my God, with
I
Sarah.
have to turn off the TV because he'll already cry and want to send all his money to the ASPCA or whatever.
Make it so sad. The music in the background.
Yes,
I know.
Like Sarah McLaughlin playing in the background. Yes, he gets so sad. But in the meantime, he doesn't want to walk his dog or pick up the poos,
No, he's in the air conditioning. Fine.
It's this one, Marie.
Yeah. Arms of an Angel, yeah. There's no sound, but I know.
Oh, that's too bad because it's playing.
Yes, it'll just make me sad. Don't play it.
Okay, but that's the song. And with the doggies.
Yeah, Mateo, I hate those commercials that come on because he gets so sad. And then he tells me, I don't want to watch any movie where a dog dies.
Ooh, chihuahuas.
Welcome back to Time Serve, the channel that scans the docket so you don't have to. I'm Phil, and another day and another way the Daily Docket gets filled with liars, deadbeats, cursing, interpreters that aren't needed, max headroom, and panda bears, and maybe even a fox. Judge Washington has a lawyer who needs to practice what he preaches as he's sentenced in his OWI case. It's a good one, and hopefully it turns out for the better. Speaking of the OWIs, this ginger over here needs to watch his mouth before Judge Shackelford uses the soap. Nobody has any idea what these guys are saying in Albany. Judge Braunlich usually never loses his cool, but today he had enough with this deadbeat dad who not only owes $19,000 in back child support, but he refuses to find a job, and when he's asked, can't even remember the last time he held a job. No. And there are technical issues in Judge Simpson's courtroom where I think Max Headroom had an appearance today. There are just a ton of shenanigans going on constantly in Judge Simpson's courtroom, and it's losing your cool. We have a volcano of a dad who is ready to erupt, and maybe he actually does. Let's find out. And then in Georgia, there's a TPO where the judge exclaims that he hasn't been so annoyed with someone in his entire 40-year career. So just imagine how bad this TPO is. Don't forget to hit that like and subscribe, set your notifications to all, and never miss the Daily Docket. Court is now in session. Let's roll, nerds.
Front and cross-examine witnesses if you want. You have the right to remain silent. You understand all those rights?
Yes, sir.
And do you give up those rights and plead guilty to interference with police officer?
Yes, sir.
All right. How long have you been in jail?
I don't even know. They keep that one in the morning. I think it was yesterday or the day before.
Judge, he came in yesterday.
Oh yeah, like 5 in the morning though. But real early in the morning though, like it was early in the morning I came to.
Do you work?
No, I don't have a job.
Well, how do you eat if you don't have a job?
I'm still going to disability junction and stuff.
You getting a disability check?
Yeah, that's how you know what I'm saying. My they still take care of me, but I used to get a disability check. They still going through it.
I didn't understand what he said.
I didn't either. Speak up.
Like I get a disability check, but my mom, she still take care of me. Like, you know what I'm saying. She
His
still
mother-
helps me because she's like over my, I don't know.
That's your mother.
Yeah.
His mother takes care of it.
His mother is over his check, Judge. She still takes care of him. He has some mental issues.
Okay.
Social security check.
Mr. Ledford, do you know what the interference was about?
I really do not. It apparently got a little age on it, Judge. But he's pled guilty to interfering with the police.
And how did you interfere with the police?
I was coming from the store. I think somebody broke in the store over there, and I was walking across the street. They wanted to ask me some questions, but I ran. He told me to come in, and he started running after me, and I had run around the corner. And he told me to stop. I told him no. But he was like, I should never stop because somebody broke in this in their shed or something. Somebody broke in this store right here, and I don't know. And they thought it was me, but it wasn't me. So he just charged me with interfering because I want to stop for him.
Why did you stop for him?
I don't know, because I didn't do it. They had a lot of police out there. They was just like, we just stopping people to get them. But I had ran from him. He was like, stop. I was like, nah. I don't know. I didn't do it though. Somebody broke in their shed. I didn't do it though. I just didn't stop for him. Somebody had broken their store. I don't know who broke in it though. But it was a bunch of police out there. They know I didn't do it. It was a bunch of them out there, so I didn't do it though.
How old are you?
I'm 24. I just turned 24.
All right. I'll give him credit for time served.
Yeah, thank you, Judge.
Yeah, thank you, Your Honor.
Come on, this one. This way.
This is Ronald Mingo. He's got 4 charges: failure to appear, tag's been altered, have improper plates on the car, I guess, no insurance, an expired tag. He's pled nolo contender to all 4 charges.
All right, Mr. Mingo, do you understand you have the right to a trial? Sir, are you?
Sir.
Do you understand you have the right to a trial?
Yes, sir, I do.
All right. Understand that you can have a jury trial.
I understand that, sir.
All right. You have the right to remain silent, and you have the right.
I mean,
I'm telling you your rights. Can you hear me?
yeah, I hear you, sir. I understand my
Right to have a trial?
Well, no, I gotta recite them to you. You understand that you have the right to confront and cross-examine witnesses against you.
Yes, sir.
All right. And you have the right to subpoena those witnesses.
Yes, sir.
All right. Do you waive all those rights? You give up all those rights and you plead guilty to those offenses?
I mean, I ain't pleading guilty to it. It's been over 5 years. I've been locked up in Daughter County Jail 5 years, 2 months. I don't see why it took them that long. I even got out last year, November the 30th. And I just got locked up Monday, and all this just resurfaced back up. I don't even see how I didn't even take care of that. And let statute of limitation ran out. I stayed in county jail 5 years, you know. And now I'm just not coming to court on this. That happened in September the 14th, 2017. I had a court date the next day on the 15th, but I got locked up. And I told Deputy Brian, the guy on the gang unit, that stopped me and gave me the ticket. He said, if I bring the insurance card and show it to him, he'll just dismiss it. So that been over 5 years with that year.
Okay. Hawkins,
Sir,
Deputy Hawkins,
yes, sir.
is he here does he have a hold from another case?
Yes, sir.
Probation
Judge,
violation.
he is here on a felony probation violation.
Okay. All right. Have you worked? Do you work?
I'm currently working now, so I work at a Bird Song Peanut Company in Sylvester.
What? You said you were in county jail for 5 years? For what?
I got incarcerated September 14th, 2017. They had me charged with burglary. And it just took them out of there a long time to even get me in court. I stayed up here 5 years, 2 months. And I don't see why. I've been trying to get in city court to take care. I got locked up on the 14th, and I seen Officer Brian, and I told him, could you let them know that I ain't gonna be able to make the court the next day, which was gonna be on a Friday because I'm locked up. And he said he would. If I can get somebody to bring the insurance card, he told me he'll insure it to him. He'll do away with the whole traffic stop thing. But I guess he did. So he got sitting down though, young.
Yeah, Judge, these are 2017 cases.
Merited that those patrol responsibilities.
All right, well, I doubt we can make them. All right, I'll give you credit for time served.
All right,
All right, thanks, sir.
you're done with this.
All right, thank you.
Good luck to you.
Got 'em. Okay, all right, so now we have everyone here. I'm sorry, Mr. Fanto.
Again, Jeffrey Fanto on behalf of Mr. Terry, excuse me, my client's prepared to plead guilty and amended charge of operating while visibly impaired. Driving while license suspended would be dismissed. I see the Mr. and Mrs. Maruza are present. I would ask that they submit any proposed restitution out-of-pocket expenses they may have to the probation department. Mr. Terry knows he'll be referred to probation for a pre-sentence interview. We'd come back for another day for sentencing. So if we could get that information from the Maruzas, if any, that would be helpful at that point.
Okay, all right, and yeah, Mr. and Mrs. Maruza, I'll address you on that in just a moment, okay? So Mr. Terry, do you hear everything your attorney just said?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
And did you go over your constitutional rights with your attorney outlined on this advice of rights form?
Yes, ma'am.
Did you understand those rights?
I did.
And did you give your attorney permission to sign your name on the advice of rights form?
Yes, ma'am, I did.
You understand that if you enter a plea of guilty to operating while impaired, that you'd be waiving those trial rights. There will be no trial of any kind.
Yes, ma'am, I understand that.
You understand if you're on probation or parole and you enter a plea of guilty, it could be a violation of those conditions.
Yes, ma'am.
And sir, you understand operating while visibly impaired is a misdemeanor offense. And it's punishable by up to 90 days in jail, fine of up to $300 plus court costs and statutory fees, up to 360 hours of community service and 4 points on your license. You understand that?
I do.
Knowing all of that, sir, how do you plead to the charge of operating while impaired?
Guilty. I was guilty.
Okay. Has anyone forced you to get you to plea?
No, ma'am.
Has anyone promised you anything other than the plea agreement to get you to plea?
No, ma'am.
Are you pleading guilty of your own free will?
Yes, ma'am. I was going through some shit.
You're in court. Just calm down, Mr. Terry. We're gonna get through this, but like the last thing the judge wants to hear is like profanities while I'm trying to take a plea. Okay?
Yes, ma'am. Understandable.
Just take a deep breath. We're gonna get through this. Okay. So back on January 21st of 2022, were you operating a motor vehicle in the city of Taylor?
I was.
And when you were operating that motor vehicle, sir, was your license either suspended, revoked, or denied? I'm sorry. Now I'm frazzled. Okay. Mr. Terry, while you were operating that motor vehicle, had you had something to drink prior to driving that vehicle?
Yes.
All right. You remember what you had to drink?
I do. It was a couple green teas.
Okay. And did that alcohol affect your ability to drive a vehicle?
Yes.
Yeah. Mr. Fanto, do you know what the BAC was?
0.153, Judge.
A 0.15? Okay, so almost twice the legal limit. Mr. Fanto, are you satisfied with the plea?
I am, Judge.
Okay. All right, I'm satisfied as well, so I'm gonna accept the plea as knowing and voluntarily given. So sir, you're gonna be referred for a pre-sentence investigation and an alcohol assessment. You'll meet with the probation department. You're gonna get notice of that in the mail within the next week. Mr. Terry, if you don't get it in the mail, it is your responsibility to call the court and make sure that you don't miss that date. Do you understand?
Yes, ma'am.
Okay, and after that occurs, then sentencing will occur. Mr. and Mrs. Maruza, I hope I'm saying your last name right, I'm guessing. Okay. You will also be contacted by the probation department. You have a right to make a statement to the probation department, provide any documents you may have supporting any loss that you may have incurred, out-of-pocket losses. Obviously, if there was an insurance policy or something of that nature, you know, it's best that you just make sure that's available so we know what the deductible was if there were out-of-pocket expenses. I see I have a pile here, Mr. Fanto, and I don't know, it looks like these are documents that were provided by
Ms. Manarino indicated there was some stuff in the file, which I did not see, Judge, but the probation department can, I'm sure, go through those and make its appropriate recommendation.
Okay.
Then
All
we'll
right.
take a look at sentencing.
All right, so we'll make sure we look at all of that. If there's anything that you haven't already provided, make sure that you produce that. You'll also get notice of the sentencing date. You have a right under the Crime Victims' Rights Act to make a statement at sentencing. And at sentencing, we will address restitution at that time. If we need another hearing, we'll set another hearing at that time. But for now, we're all set. I've accepted the plea. And Mr. Terry, you'll hear from the probation department. Make sure you show up for that visit, okay?
Yes, ma'am, and I apologize for swearing in your courtroom.
It's all right. People get nervous when they come to court. But do you know you're not allowed to be drinking right now, right?
Ma'am, I haven't drank since I screwed up and got my DUI. I learned my lesson. I was dealing with two grandmothers.
I don't want you anything. You have Mr. Terry, talk to your attorney and the probation department. You have a constitutional right to remain silent. I don't want you to say anything to me that might affect your rights, okay? Especially while I can tell you're nervous. So meet with probation, talk to your attorney, and we'll address all that now. But your bond conditions are, while this case is pending, because I was looking in the file to see them, these are your conditions. You're to appear in court as directed. You're not to leave the state without permission of the court. You're not to commit any new crimes while released. You're to immediately notify the court of change of address or phone number. You're not to consume alcohol or illegal drugs. You can't operate without a valid license, and you may be subject to testing on demand at your expense.
Yes, ma'am.
All right, and we'll make sure you get a copy of those bond conditions as well, and you're all set, sir.
Thank you. I appreciate it.
All right, we're all set. Thank you.
You can sign off, Mr. Terry.
Taking of an automobile 2-year.
And that'd be a felony?
It's a high court misdemeanor.
Okay, so would that still be on the table after I find out? Yeah.
Actually, we can talk about this.
Okay, we'll talk about it at a later day. Okay, thank you.
And you're asking that this be put out after August, and you said 24th?
23rd is the court date.
We can set it for Monday, August 28th at 9 a.m. Does that work for the parties?
Yes, Your Honor.
Works for me.
We'll set this out to August 28th, 2023 at 9 a.m. Ma'am, if you're still incarcerated, Washtenaw, we'll make arrangements to Zoom.
And one other question about the bond thing. Is it?
Oh, I'm going to make sure that, Your Honor, I believe Miss T was originally given a PR bond. I believe we gave her a short low cash bond, Your Honor, so that she would be.
I just want to
receiving
make sure
title.
it counts, yeah. Like my time is counting.
Ms. Mayor,
Sorry, Your Honor.
do you have anything you'd like to add to Ms. Underwood's request?
I just wanted to confirm that.
Someone for 2 and someone for Doc.
What I'm reading, I believe we placed her on, I think it might have been a PR bond, and then Washtenaw came and got her.
I know, but then I had called and asked them to change it to a regular bond. Sorry.
Address bond on the 28th. I'm not going to change it.
Well, can we change it to a cash bond of $100, Rob?
This moment in time, I'm not going to adjust it.
Because
I understand.
she's in jail, Your Honor.
She's in Washtenaw County Jail.
Right.
Not London.
But she would,
I understand. At this time, I'm not adjusting the bond.
That's okay. Thank you, sir.
Your Honor.
Give me copies of paperwork and advise of your rights. That's true.
Yes, sir.
Based on your application, finds you do qualify. I'm going to go ahead and appoint the public defender to represent you. Any question about that?
No, sir.
Deputy, criminal history?
Have a habitual 18, habitual 15, hit and run, habitual traffic, butanidol, VOPs through 16 on those. History locally goes back to the 90s.
Okay. Mr. Rice, you just going to drive, huh? Okay.
No, sir.
All right, Mr. Rice, I find that you're a danger to the community. We'll hold you without bond. Your court date September the 14th at 9 o'clock.
Okay, I don't get a bond, sir?
No, you do not get a bond.
I came back to the scene though. I came back to the scene. I did.
You are so terrible at driving that they've taken your driver's license away forever, right?
Forever? I haven't had one charged for over 5 years, I believe, or it's been about 5 or 7 years.
Well, don't drive anymore.
Sir.
Step to your right, sir.
You're not good at it.
Able to pay because she's got more than one ticket that she has, around the county that she's resolved.
And when,
Thank you.
I guess,
Anything you want to say, Mr. Barnett? That's a different case.
If you will, from the state bar, in addition to what the court does. He's engaged counsel in that regard as well. But most importantly, when I said I'd skip over and come back to himself, Your Honor, Mr. Hall had to make some life changes and did. He immediately got into the AA community prior to ever coming to court. He did 91 meetings in 90 days to start. He's totaled over 130 days to date in AA attendance. He got into he did get screened, assessed, got into Dawn Farm and not only attended, but completed the discovery group. He's also made a lot of personal changes that he's going to describe to you. I'm not going to say the things he's going to say, but they focus on individual self-improvement and therapy. And also, Your Honor, most important, I think, to the court and to the concern of probation, he's got a network around him and a plan for what he will do if and when he experiences any urge for any relapse or temptation. And I'm going to let him speak to that, because that's always the concern when we have a high blood alcohol level and the other markers here. Your Honor, with respect to the recommendation, I'd ask the court not to consider the advanced behavioral rehabilitation insight and awareness course. And I don't mean disrespect when I say that to this course. It's kind of redundant to that. Well, I shouldn't say kind of. It is redundant to that which he has done. And maybe the court's mindset would be, well, we can always benefit by more education and treatment, I suppose, but I don't know that it's necessary here. And in fact, Dawn Farm doesn't usually say things like no additional professional intervention is recommended. If they feel otherwise, they say otherwise. I also asked the court, there's random testing we expect if the court places my client on probation. But 2 times per month, we asked the court to just make that just random versus a scheduled amount. He's going to have a lot to do, and not only with the court, but also with his professional obligations in his practice and also his professional obligations with the state bar. So I'm asking the court to just make that random if it would consider versus a manual or minimum amount of times to test. The continuation of AA meetings, he's definitely going to do that. A minimum, I don't know that that's necessary here. He's going to speak to you what he's doing, but I'll ask the court to hear him out on that. And just one last comment from me. We respect that there's a period of probation that's recommended. I told Mr. Hall and I are
advanced behavioral rehabilitation put you and myself in this awkward situation. Since that time, I've taken significant steps to address the root cause of the problem. As you know, I do this, I deal with this type of offense quite regularly. And I've told a lot of clients to do 90 meetings. And
that's a whole nother court. Yeah.
In 90 days before the court orders it. So I figured now would be a good time to practice what I preach. I did so. I gained a lot of insight, awareness from that experience. I realized that there were certain things in my life that were lacking. For instance, greater spiritual fitness, self-reflection, having support of others, not trying to do everything on my own, and self-care. I mean, in our business, you spend, well, most of the time dealing with other people's problems. And, not that I would ask that anyone feel sorry for me, but sometimes you don't recognize what the wear and tear that is having on you. I also have 2 teenage children, who I have one daughter who will start at University of Michigan Ross this fall, and I have a son that's going to be a senior in high school. So having to talk to them about this incident and was very humbling, to say the least. Again, I did the 91 meetings in 90 days. I continue to go to 1 to 3 meetings to improve myself.
I think more than that, I appreciate the deep dive that you are taking to take a look at how you got here and the things that you can do to make sure that it doesn't happen again. It is awkward, and your acknowledgement of that out loud, not just, an internal thing, means a lot. I read this and, I was saddened that you're here, but I am glad to see that you're taking it as an opportunity to be a better person in all of those aspects of your world. Mr. Simon is correct. It is not often that Don Farm says that they don't think that a person needs additional support from a professional standpoint. And I take what they have to say very seriously. On the other hand, I also have to make sure that I'm protecting the community. And so I'm trying to figure out what that balance is in terms of what the community needs and what you need. So therefore, it is my sentence that you serve 93 days in jail, credit for 0, the balance is suspended. You must do the 3 days of community service. I am going to place you on probation for 9 months because I believe that rehabilitation in terms of reviewing and making sure that you're continuing down the right path is necessary. As your attorney has said, You are eligible for early discharge when you get to the halfway mark to make sure that you've done everything you're supposed to do. Fines and court costs in this particular case for a total of $1,295. $30 per month in probation oversight fee. You to report to probation online monthly. And I'm going to waive the advanced behavior rehabilitation class. I don't think it's necessary for you. For some people, it may be, not for you in this particular circumstance. There's no use of possession of alcohol, marijuana, illegal drugs, or paraphernalia, no being in the presence of anyone using that. No use or possession of any firearm components, ammunition, or other dangerous weapons. The Sober Link will be discontinued, but I am going to require that you do random tests for 2 times per month. I think it's necessary for us to make sure that you are continuing to do what you need to do. In terms of the 12-step meetings, I am going to, you say you do up to two a week at this point?
I do 1 to 3 typically.
Right. So I'm gonna require that you do a minimum of 2 per week, but I'm gonna require something additional. I think you need a sponsor. I think you need to have someone who's walking through this process with you for a while. So I'm gonna ask that you get one of those so that you can have someone else to talk to. I don't know if you know him, but there's another attorney that does this work. Maybe it would be good for you to see if he's willing to take you on. I'm sure Mr. Simon knows who that is.
I do.
And he can talk to you about what you're going through. He's been through it. And sometimes that's useful. He will not be too imposing. He will only give you what you need. So you won't feel as though I know you got a lot on your plate.
Not attending the right meetings or whatever the case may be. But if the court requires that, I will do that.
Do you know who I'm referring to, Mr. Hall?
Is he in Saline?
Yes.
Yeah.
That won't work out. Okay. All right.
I was partners, or well, we worked out of the same law office.
I see. Gotcha. All right. Thank you. All right. Well, I'm going to give you some time since you're already
Truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
State your name again.
Stephen Berry.
Okay, you can put your hand down. All right, Mr. Berry, it's this court's understanding you're going to plead guilty to the charge of larceny less than $200.
Yes.
That's a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court costs. The fine can be increased at 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that, sir?
Yes, sir.
Now, understanding all of that, you still wish to plead guilty. Is that correct?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
All right. Because of that, you're also then giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent. It is considered a violation of your parole. You could be sent back to do the remainder of your time. You understand that, sir?
Yes, sir.
Understanding that, do you still wish to plead to this charge?
Yes, sir.
All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plead to this charge?
No, sir.
Anybody threaten you or coerce you? Mr. Berry, has anybody threatened you or coerced you to plead guilty?
No, sir.
You're doing this voluntarily and of your own free will?
Yes, sir.
And because you believe that you're guilty?
Yes, sir.
All right, hopefully we won't lose him. April 29, 2023, at the location of 771 Airport Boulevard. Yes, Airport Boulevard, Pittsfield Township, Washtenaw County, State of Michigan. What'd you do on that date that makes you think that you're guilty regarding a wallet belonging to a Paula Muse?
I removed the wallet out of a shopping cart.
You did what now?
I removed a wallet out of a shopping cart.
Okay, and then you took it and tried to walk out without it?
Yes, and then when he stopped me,
Or with it? I'm sorry?
When he stopped me, I turned around, went back in the store with him.
Okay. Your intent was to keep that wallet, is that correct?
Yes, sir.
All right. And you didn't have any property interest in that wallet. It didn't belong to you in any way, did it?
No.
All right. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Defense is also satisfied, Your Honor.
Court will accept the defendant's plea of guilty to this charge. Defendant is referred to probation for pre-sentence investigation and report. Sentencing in this matter will be September 13th, 2023, 9 a.m. or as your
Your Honor, I believe you've lost audio.
I can hear, I can see you. No, I can see him. Yeah. Yeah.
All right. Mr. Hawthorne, can you hear me now?
Yes.
Okay. I don't know where I dropped off or what happened. Mr. Berry?
Yes.
All right. I accepted your plea. Did you hear me say that?
Yes.
Okay. And I've referred you to probation, set your sentencing date for September 13th. You got that?
September 13th?
Yes, at 9 o'clock or as your Zoom invite indicates.
Okay.
Okay. You just need to stay right where you are. Don't you push any buttons because we know that doesn't work out real well with you. So you stay right there and I'm going to put you into a breakout room with our probation department so they can get some information so we can start on the sentencing process. Okay.
All right.
All right, Mr. Berry, you take care. We'll see you in a few weeks.
Thank you.
Thank you. Court calls the case People versus Daniel Morton.
Maria Rosinski on behalf of the people.
2023, it was a first finding with a 38-day balance. So Mr. Leiter I proposed the front of the court's recommendation for sentencing was for 10 days immediate credit for the 4 days he has served. So he would still have a balance of 6 days to serve. I did not tell him the dollar amount. I would ask that the dollar amount stay at $1,000 as this does have a current monthly support obligation of $990. So he could either have somebody post the $1,000 so he could get out or spend the next 6 days in the jail as nothing else has seemed to work for Mr. Brinson when we've been bringing him before the court.
Thank you. Reviewing the court file does appear that Mr. Brinson was arrested on a bench warrant back on March 27th. He pled guilty to contempt at that time. The court urged him, suggested he file a motion to reduce his sport obligation and pick up a jobs list. Did he ever do that, Ms. Hicks?
Your Honor, he might have picked up the jobs list, but when we came back on April 25th, you had ordered him to come over that day, pick up the jobs list, and begin applying to 5 jobs per day on that day and provide verification to the friend of the court, and that he could stop that amount of applications if he were to gain full-time employment. And we adjourned the matter to May 23rd. He then failed to appear on May 23rd, has not made payments, has not provided verification that he's been applying to any employment, and that's when the bench warrant issued that he was subsequently arrested on.
Right. Was this a second finding of contempt or first? Is it a 90-day?
First finding, Your Honor.
So Mr. Brinson previously served 7.
Correct. So he has 38 days hanging over his head, and the 7 days that he served when he was found in contempt, he was sentenced to 7 days immediate credit for the 7 days that he was already in the jail. He was ordered to pay $1,000 and we adjourned it over. He hadn't paid that $1,000. I elevated it to the court. The court then ordered him to instead pick up the jobs list, apply to jobs. And here we are.
Well, to be honest, this court does not believe that we've not actually caught Mr. Brinson's attention. So I don't think 10 days is sufficient. We gave him 7 days before. He didn't file a motion. Mr. Brinson, I know you well from past PPO violations. You have an alcohol problem. I've told you, you got to get some treatment. You got to stop drinking and get some meaningful employment. Seasonal job is not adequate, Mr. Brinson. So what's going to get your attention? I do not believe 6 days in jail will get your attention because you're not going to do anything. You're not going to do anything. You're not going to get jobless. You're not going to reach out. I get you a job today, Mr. Brinson, but you don't want a job.
Your Honor, I picked up that list.
The court's not going to accept his recommendation. He needs Mr. Brinson unless all he's got to do is come across the street and file a motion to reduce his support. It's clicking wrong right now, Mr. Brinson, $1,000 a month. You're making my job very difficult because you won't do anything. You're not even filing a motion. We'll waive the filing fee, Mr. Brinson. You got to get off your duff and do something.
I understand that, Your Honor. I picked up that list. Miss Hicks actually left it in an envelope. I picked it up that day like you requested me to do. I don't have transportation. I don't have a license. I filled out every single place that I could get to on my bike, from the Family Dollar, the dollar store over in the Kroger complex in Monroe Street. I filled out Wendy's, McDonald's, AutoZone, I think it's O'Reilly's. I filled out the American Diner restaurant. Most of them were online, so I only had like proof of 3 that were actually paper applications, and I didn't get a call back from anybody. I filled out at Gordeau, which is a steel mill that I can get to on my bike. I filled out everywhere that I can, legitimately get to on my bike. I can't try to get a job across town if I don't think that I can get there on a daily basis. But I have made an effort. I understand what position you're in, but I did make an effort.
Why, Mr. Brinson, why didn't you follow up with Ms. Hicks? Why didn't you tell her that all these things you did? Why didn't you appear on May? Let's see. You failed to appear. The matter was adjourned from April 25th to what date? Ms.
All
Hicks?
right. May 23rd, Your Honor.
Okay, we don't have that. Why didn't you appear on May 23rd, Mr. Brinson?
If I could be completely honest with you, I hadn't got a call back and I didn't have a job and I hadn't made a payment. And this isn't right, but my middle son's birthday was May 29th, and I thought you guys were going to put me in jail and I didn't want to miss his birthday. That's not okay. I understand that. I know that.
Mr. Brinson, why have you filed the motion to reduce your support? You've been suggested and told that many times.
I picked up that paperwork too, but I think I've told you in the past, I do believe that I owe that child support. My kids do deserve that child support. I didn't fill that paperwork out. I thought I would get a job, to be completely honest with you. And I didn't.
It's pretty significant support obligation, $1,000 a month. What are your wages right now, Ms. Hicks?
Including the month of August, $19,009.60, Your Honor.
Mr. Brinson, you're going to soon be charged by the Michigan Attorney General with felony non-support. You're looking at a felony charge, you go to prison for not supporting your children. Be smart and file a motion to reduce your support. It's $19,000, Mr. Brinson. It's adding another $1,000 every month, Mr. Brinson. I don't know. Nothing more this court can do. I probably told you 5 times, Mr. Brinson. So was Ms. Hicks said, file a motion to reduce support. All right, yes, Mr. Later, anything else you want to say on behalf of Mr. Brinson? I'm not sure he's until the court appointed attorney, but Judge Lohmeyer broached that subject.
Your Honor, and I understand that. And I certainly do appreciate the court's consideration and indulgence in this, Your Honor. And I understand the court's position. I did talk to Mr. Brinson and pressed upon him the importance of filing a motion to modify. That certainly needs to be done. And I told him he's skating real close to the edge of the felony matter with Ms. Courtwright in the Attorney General's office. We'll just have to kind of go from there. But Your Honor, if I may, I'd still like to. I understand the court's position all totally well. I did advise Mr. Brinson that it was a recommendation from Ms. Hicks. I don't think we had a sentence agreement. And I understand the court's position on that. I would still like to ask the court to seriously consider allowing him to be sentenced as per the recommendation that Ms. Hicks had. So other than that, I have nothing further.
Thank you. Mr. Brinson, when did you last work?
I don't know 100%, Your Honor. It's been at least 4 months since the last time I worked.
Mr. Brinson, you're able-bodied. You are capable.
I am.
You're a merchant, finding where you can get money you've always got money to buy vodka. Mr. Brinson, you never have trouble with that. I mean, Michigan bars hiring for dishwashers. Mr. Brinson, you've done going great. The court can order you serve 38 days in Monroe County Jail. Give them credit for the 4 days you have served. Balance of 34 days you serve immediately. You release my post $1,000 cash bond. Mr. Brinson, you've tested the court's patience way too far. There's no reason. It's summertime. You get a bike. If you really want to find a job, you could have found one. So So when you come back to review, reach out to, I doubt if the mother of your children will post $1,000 cash bond on your behalf. So ensure the next 34 days in jail, but you can be released this week by posting $1,000 cash bond to apply towards your urges. I'm going to come back for review, Mr. Brinson.
Can I ask a quick question? If the mother of my kids were to write off $1,000, that does that count as posting $1,000 bond or no?
No.
Okay.
Ms. Hicks, what do you suggest review date?
So if he's going to do 34, Your Honor, I would put him on October 31st at 8 a.m.
Okay, Mr. Brinson, your order to appear before Ms. Hicks, October 31st at 8 a.m. I will suggest you, if you're not employed on that date, now after you don't appear, the bench will issue. If you don't have a job on that date, we're going to start contempt proceedings over again. It'll be up to 90 days at that time. It's a second contempt finding. So you give it some thought, Mr. Brinson, where you want to go with your life. You want to spend it all in jail? That's where we're going to spend it. You need to get a job. So you support your children.
Yes, Your Honor.
Copies order will be emailed to the judge. Get a copy of this. Make sure you keep it with you when you leave. Anything further, Ms. Hicks or Mr. Later?
Nothing further, Your Honor.
Okay, Mr. Brinson, you can step out. Thank you, Mr. Later.
Oh, Your Honor, I'm sorry. I was muted. I just wanted to say, Your Honor, would the court consider, since Mr. Brinson does have the paperwork, he does have the motion for modification. Would the court consider maybe an earlier release date if he does complete that and files that, brings proof to the court that he's at least moving in the right direction?
Unfortunately, Mr. Later, it's been time after time after time the courts suggest you do that. So the court's not convinced he can do that. So no, he needs to spend some time in jail to realize that this is a serious obligation. He got $19,000 of urges, hasn't worked in 4 months, and he's physically capable. All right, that concludes the matter. Thank you, Ms. Hicks.
Thank you, Your Honor.
Any motions, Later?
His mother, Jan Camrath, is here.
Okay. So typically, I know that I have less concerns with the 16-year-old, but typically with the younger child, we would not have them present at this stage unless we're talking about taking testimony. Are you able to turn your camera on?
Yes, here, hold on, I can. One sec, it's the school computer. I have to. Okay, we're here.
Okay. So let's talk first about, this is a new filing. I did see that our court on an ex parte basis approved the immediate order and hearing notice that you filed. That was done on August 8th, and then it was set on for our hearing today.
Yes.
What I want to first look at, I see Mr. Murphy, you are there.
Yes, ma'am.
As respondent father, and Ms. Murphy, I see you there as respondent mother. Is that correct?
Yes.
Okay. Have both of you received service of the emergency minor guardianship petition?
Not technically, but I don't know how to answer that question really.
Nobody's served me any paperwork.
Okay.
I had found it on the counter at my house when I got home 2 days ago.
Okay. So Ms. Harrington, at this point, I would like to ask the kiddos to be in a different room, especially the younger one. I don't think, as we work through these procedural steps, I don't think it's beneficial to them to be present.
Yeah, she's going. The older one was the co-petitioner, though.
I understand, and that's why I said my biggest concern was the 10-year-old. I did see the statements from the 16-year-old, and I'll probably talk to her about whether she wants her own attorney.
Okay.
Okay. So that was one question I had was I'm not finding that the two parents have been served. What can you tell me about that?
They were both served by Jeremy's ex-stepmother. Well, I guess they were not technically married, but Jeremy's, hold on, I wrote it down when it happened. She went to the police station to document it.
But that didn't give me the paperwork. I didn't receive it until 2 days ago when I got home. It was sitting on my counter.
Okay, so Mr. Murphy, let me just ask you, have you now received the paperwork, which should be the petition and the immediate order?
All I've got is immediate order.
Okay.
That is all I have received.
You don't have the original petition that was filed?
This is a photocopy. What I have is a photocopy. And no, I do not have the original. I have an immediate order. That's it.
Okay. So Ms. Shannon Murphy, have you received any of these documents?
I've received the same thing that he has.
Just the immediate order?
This is what they received.
Yeah, that's the immediate order. Have they been served with your petition?
This was all that the
No,
court gave me to give them.
Well, okay. That's a little different than what I'm asking you. You are the one who you and the older child initiated the request for an emergency guardianship. That is the paperwork that needs to be filed on them, so they know how to respond to the allegations that serve as the basis for your request. So that's what I'm trying to ask. On the last page of your sheet, I'm not seeing where you, in your motion, where you served them with the statements that you have filed with the court about why you're requesting this.
We went there to ask, what it is that we actually serve, and he gave us these 3 pieces of paper and said that we couldn't do it ourselves, that it had to be done within 48 hours. He only gave us 1 copy, so I thought that I would make copies of it and have that delivered to them. I thought that's what I was supposed to do.
Okay, well, it's a little different than that. And if you read the instructions on the motion that you filed with the court, it does state that you have to serve all other parties or their lawyers a copy of your papers. Okay, so that's on the very first page. Not faulting you for that. I completely understand that working through these proceedings can be difficult. But
it's a lot.
It is, but we do need to get them served before we can make a decision on whether this is in the best interest of the children. So let me first ask before we set dates and talk about.
We are in process of submitting an objection.
Okay, so Mr. Murphy, are you and Ms. Murphy both objecting to the guardianship?
Absolutely.
Okay.
Yep.
Okay. And are you seeking representation on
Yeah,
this?
I am. I'm just trying to come up with the money at the moment. I do have an attorney lined up, but I have to have the money for it.
So you are seeking your own counsel?
Well, if I can, I'm trying to come up with the money. That's the problem. I've got to come up with the money.
Okay.
And I'm trying.
Okay. Do you think that you would qualify for court-appointed representation? I don't know if you're working
Yes.
full-time.
I'm working full time, but I've been out for the last 7 weeks on an injury.
Okay. Are you receiving any income for the last 7 weeks?
I've received 1 small check from L&I.
Okay. When you were working full-time, just approximately how much were you making?
$30 an hour. I was making about $1,000 a week or something.
Okay.
Roughly.
When do you expect you'll be released back to work?
Hopefully by the beginning of September.
Okay.
They were wanting surgery and we're trying to go around that.
Okay. And how many dependents do you take care of on that salary?
Well, right at the time, would be myself.
Okay.
I live with and obviously the girls are not here.
Okay. So you probably would be well above our guidelines for court-appointed counsel. When we set the review date, let's re-review that issue. If you still aren't working, I can reassess whether you would qualify for court-appointed counsel. Okay.
Sounds good.
In the meantime, I'll just make a note that you're seeking your own counsel. Ms. Murphy, what's your status as far as income and whether you're seeking counsel in this proceeding?
I work full time, but I make less than $18 an hour, and I was taking care of the girls. So I would absolutely pursue some kind of help.
So what would you say, what do you bring in per month on your salary?
I don't know off the top of my head really right this second. I don't know.
Let me ask you this, which might make it easier. Do you receive any sort of state assistance, including like state medical or food stamps or anything?
Yeah, I receive food stamps, yes.
Okay, then you do qualify for court-appointed counsel. So
okay,
I will appoint an attorney to you at county expense. I'll fill out that order. Again, just like I said to the prior case, I don't have the name of that individual. I'll have to get it from court administration, but we will get an order filled out.
Okay.
The next question I want to ask, and Haley Murphy, is she the 16-year-old?
Yes.
Okay. Is she present there with you, Ms. Harrington?
She can be.
Yeah, could you call her back into the room?
Haley.
Hey, are you Haley Murphy?
Yes, I am.
Hey, Haley, I'm Commissioner Jill Carmy. I'll be hearing some or all of this case. Do you want to be appointed your own attorney through this matter?
Yes.
Okay. And are you, I'm assuming that you're currently in school, or you will be as soon as school starts?
Yeah.
Okay. So we'll get an attorney appointed for Ms. Murphy. And then I think what we'll do in this case, and Ms. Farr, I have you here, so I might pick your brain if you don't mind. We do have some questions about service. At this stage, would you recommend the court appoint a court visitor for that? Both parents are here, so they've had some notice.
So since both parents are here, they can agree to, both of them can agree to accept service by email, and that should resolve the problem without appointing someone.
Yeah, that's what I was kind of wondering. So I appreciate your input on that. Thank you.
You're welcome.
So Mr. Murphy and Ms. Murphy kind of circumvent having to add even more players to the case right now. And that's not to say at some point we don't appoint a guardian ad litem. But at this point, just for service, do the two of you have an email that you would agree to accept service of the petition on so you can see what allegations are being made?
Yes, of course.
Okay. So Mr. Murphy, why don't you give me that email?
It is JRM Murphy 79@gmail.com.
And say the last part again. I got JRM Murphy 79.
Correct.
Ms. Harrington, did you write that down?
I did.
Okay. You'll be serving your motion, your petition on him at that email.
Is that at Gmail?
Gmail, yes. Okay. And then Ms. Murphy, what is your email?
So I don't know if I'm okay with that. If she can just send me, she can just email me anything that says.
Now that I understand fully.
Mr. Murphy.
No, it needs to be handed to me. That's not okay. I'm not doing it over email. That's not okay. I was misserved. Nobody gave me this last set of paperwork. Nobody handed me nothing. They sat on my counter when I got.
Mr. Murphy, stop.
Okay.
Ms. Murphy, stop.
Jeremy, stop.
I'm going to mute you in a second. Stop. Ms. Murphy, I'm talking to you before Mr. Murphy interrupted and went on his tirade. Ms. Murphy, why are you not okay with getting an email that circumvents a lot of the issues in this case?
I'm not familiar with it.
You're both making this more difficult than it needs to be.
I'm not familiar with the situation. Does that mean she can just make up other things and email it to me, and then that means that I've been
no? What I'm asking, you're both here, okay? Both of you, Mr. Murphy, Ms. Murphy. You're both here, which means you have notice of this hearing. Frankly, I could tell you to come to court and get a copy of the motion, but instead I'm asking Ms. Harrington to serve it on you. Okay, most of the time when there is lack of service, the parents don't know about it. And so we have to appoint someone to go find them. Thankfully, you are both here. You did the responsible thing and showed up. What I am asking is if you will allow the papers to be emailed to you so that you can see what the allegations are against you. The alternative is she can have a sheriff serve them on you if that's what you want, but this is a much easier route. Oh, Mr. Murphy, you're shaking your head. You want the sheriff to come serve you?
The sheriff come give me the paperwork. Well, I mean, because I wasn't even served with the paperwork.
All right.
I wasn't even served with it. And she didn't even give us all the documents.
All right, Mr. Murphy, what's your service address? Where can the sheriff find you?
Depends on the day.
I'm not going to play this game, sir. Where can the sheriff find you? Otherwise, I'm going to sign an order allowing electronic service.
I was looking at on the email thing. I did not understand that, obviously.
Do you want the paper served on you by email or by the sheriff?
Given the paperwork to begin with.
Excuse me? You're cutting out. I don't know what you're saying.
I was not even given the original paperwork or nothing to begin with.
Mr. Murphy.
Send it email, just whatever.
Perfect.
Yeah.
So you have his email. Ms. Murphy, would you like to be served by the sheriff's office or would you want to agree to electronic service?
Well, can I have my question answered?
What is your
I'm not familiar with the situation. So does that mean she can just make up more things and have it served like through email and then that makes it official? Or
no? What my decision today, if you want to agree to it, you don't have to, is that her original motion, which includes why she's requesting this petition, would be sent to you via email so that you can respond. That is it.
Okay. But I'm saying like for future, if she comes up with more things, if she makes up more things and emails it to me, does that make it, is it just for this case right now? The petition for right now?
Right now, my decision would be whether or not she can serve you by email of her original petition.
That's not what I'm asking.
We're talking about. I'm not addressing anything further in the case right now.
But me agreeing to the email is only pertaining to this
yes,
paper that she was supposed to serve.
Yes.
Hold on 1 second.
Alternatively, you can give me a residential address where you can be served in person, whatever you want.
How about residential address is fine. I'm having some issues with my email.
Do you have the chat feature so you can put it into the Zoom chat?
I'm pretty sure I do.
Okay, let's go ahead and see if that works.
Okay.
Did you find the chat feature?
Oh, I'm sorry. No.
You did not. Okay.
I'm sorry. I haven't done a lot of Zoom. I'm not super familiar with it.
Okay, let me just go to what I have. Oh, it just states unknown. Okay, what I'm gonna do, let's set your review date and then I'm gonna stop streaming on YouTube just to get your address. So what I'm gonna do is I will extend the emergency immediate order through the date of our next hearing. Let's set that two weeks out. Let me ask the court's input. I know we're assigning attorneys and dealing with service. What would you recommend? 2 weeks, at least see where we're at that point. Okay. So we're going to set you back on this docket August 29th at 10:30. Okay. And at that time, we will, if all our ducks in a row and attorneys are on board, we may discuss objections to the order. We may set a future show cause date on the emergency minor guardianship hearing. It just depends where we're at with these issues of service. So August 29th at 10:30, Ms. Harrington, you will need to serve Ms. Murphy in person. We'll get you her address. Don't log off yet. We're going to get that address. Mr. Murphy, you have his email just to serve him the original petition. Any questions for me? Otherwise, I'm going to go off of YouTube just to get Ms. Murphy's address, and then we'll adjourn docket.
I have a question.
Okay, let Ms. Harrington go first.
I just wanted to confirm that I had Jeremy's email right. Was it jrmmurphy79@gmail.com?
Yes.
Okay, thank you.
Ms. Murphy, go ahead.
I just wanted to, so I can't contact my youngest daughter and message her anymore. Like, is that what I understand?
So basically, they're kidnapped.
Let me pull up the emergency order. Hold tight.
And is this an appropriate time to ask?
Hold on. So right now, at this point, there is a one of our judicial officers, an elected Superior Court judge in this county, did sign an order on August 8th that does include a temporary restraining order against contact with the children.
That's bogus.
Okay.
That's not okay.
And there's nothing I can do about it. I just don't understand.
Yeah, I know. There's got to be something we can do about that.
Yeah, you can file an objection.
So in other words, my kid taken away from us until then? Is that what you're trying to say? They were just taken away from us until whoever decides it's okay to give us a chance to even talk about it or anything?
Okay. What I'm going to do.
What happened?
I'm telling you what has been signed by this court. I'm asking you to file.
I asked you if that's what happened.
Mr. Murphy.
God.
I'm sorry, I'm very upset about all this.
You're asking a question and you're not letting me respond. So do you want an answer?
Get straight to the answer. Just like Shannon's question. You did not want to answer that right out. You were beating around the bush and you went the long way. You know, I mean, why can't we just get the straight out answer?
Mr. Murphy, you are testing my patience.
I'm sorry, but I'm very upset about it.
I have the ability to mute you. I have the ability to mute you.
I understand that.
All right. Nope, you've been muted. So, Mr. Murphy, I'm answering your question. You can choose to listen to it or not. I already answered it. On August 8th, 2023, a judicial officer in this court did sign an ex parte immediate order granting immediate emergency minor guardianship of the two children to Ms. Harrington. As part of that order, and based on their request, it does include a temporary restraining order. This does preclude you from contact with the children. What I will ask Ms. Haley Murphy, since you are there and you are 16 years old, is it still your wishes to have a temporary restraining order in place with Jeremy Murphy and Shannon Murphy?
You do this every time we're in court. And I'm going to ask you to stop asking me questions. I'm the one asking questions, trying to get to the bottom of where we are in this case. You understand?
Okay.
Do you understand?
Hey guys, hope you're enjoying the Daily Docket. Just a brief summary of the main event. This couple has been on the docket in Georgia many times about several issues, and today is no different. This time, Dad is petitioning the court for a contempt motion because Mom is in his deceased mother's home. There's also other family members in that home as well. So he is claiming he's homeless, living on the streets, in and out of friends' homes, and he needs to get to work because he can't find a job unless he has a comfy bed at night. Judge Foxworth really doesn't fall for it, but the law is the law. Best part about this TPO is Dad doesn't know when to shut his mouth. And also his camera angles on Zoom are appalling. So without further ado, court is back in session. Let's get to the main event. Let's roll.
Understand. All right.
And I filed a contempt since May, after May 31st, and I'm still in this process right now. That's why I haven't been able to pay child support.
Okay, you
had a job.
You had a job when the 12-month order was entered. What happened to that job?
I don't have the job no more because, one, I don't have a vehicle to drive. My car was totaled by, you know what I'm saying, my son's mother, and I'm in the position I don't have nothing right now. I barely.
2 weeks ago, you said you could pay child support, so that's why I postponed it.
Yeah, I'm not able to pay it.
Well, why'd you tell me 2 weeks ago you could?
Because I thought I could, and I wasn't able.
Okay, what kind of work do you do?
Well, I was working for an apartment complex, but I wasn't able to work there as much longer. But I was working for AT&T too as well. But it's just like me having somewhere to stay and having a vehicle. It's too much. I sleep from people house to house. Sometimes I might have to get a hotel. It's kind of bad. I could barely even support food. When I'm trying to get my son too as well, my brother or whatever is never other there. So when I can get my son.
I'm just here for the best interest of my kids as well. And he should think about the well-being of his son in the process.
Okay. Y'all were never married, is that correct?
No, sir.
What?
Sir, put the camera on your face.
Okay, my
top
fault.
of your head.
So what legal document do you have saying that all of this, and go ahead, I want you to answer that question. What legal document do you say that my family so and so this and that and stuff like that? Is there a legal document, anything signed, any contract available?
No, we want I want the judge to say I can stay, and then we would submit a legal document with that.
So how do you expect me to pay child support when you know I have nowhere to go?
I don't know that you have Airbnbs. You have an Airbnb.
I don't have no Airbnbs.
Okay,
I don't
sir,
have nothing.
Sir,
okay.
Listen carefully. Do not interrupt her while she is testifying. You cannot argue with the answers that she may give. You can tell me later, but do not argue with her while she's testifying. The same would be true if she were interrupting you. I will not have it in my court, period. You understand?
Okay.
Thank you.
Mother is old and Miss Pearl is old. Why has nothing been paid on mortgage wise?
Well, one, we didn't know that the mortgage was in so much of a failure, as you never told anyone of your family until the house was up till foreclosure. So we had the talk last month sometime in order to get a contract, but I wanted to make sure, we all wanted to make sure, just for security purposes, that that I'm able to stay before I just pour all my money into the house and then ended up having to leave next week. And with you not paying child support, how would I support your son? The zoning for it.
Once more than one school zoning is over there.
Yes, and the schools for his zone.
You just said didn't you just say there's one zoning?
The school, yes, the public school for him to get on a bus. Other than that, the other schools, you have to go and drop them off, which I don't have the means to do so just yet. So, he is unable to go to them right now. The ones closer to me, the schools closer to me, you have to pay for his spot, which I cannot afford without child support.
So school isn't free for
All right,
pre-K.
excuse me for interrupting, sir. Let me ask the question. How much child support is due as of this minute?
As of this minute, it is 4 months of $449 minus $50. I can add it up on my phone right quick.
So about $1,700 or $1,800, correct?
Yes, sir. 1746.
Okay.
Another question is, so if I paid my fault that $1,700 amount, where would you have been right now? Would you still have been in the house?
I can't speak on for anything that hasn't happened.
It's either a yes or no. If I would have paid it, would you have left, or would you have been still there?
That's the future. Like, that's what if. I can't speak on hypothetical because it hasn't happened and you have no intentions of paying child support.
So is any of your kids in school right now?
Yes, my daughter is.
So how is aiding learning daily?
Okay. All right, we're getting too far afield of what we're here about.
Okay, so
what we're here about. Okay, the answer was yes or no. And
yes.
the answer is no. No one's filed anything in probate court. Have you?
Me?
Have you filed it? No, I'm talking.
I'm trying to be in the process of filing it, but I can't get it. I can't get inside my home yet. So
what does that have to do with filing with the clerk's office in the probate court? Nothing.
Because listen, you have to. Can I explain I have to get a. Oh, I can't even explain my reason.
I said sure. Go ahead.
Oh, sure.
Yeah.
Because one, it costs for it is not free. Two, number two, it's a waiting process up to 6 to 8 months.
Well, and so nobody, absolutely nobody, has legal title to this house today as we speak.
We know that
you and your siblings have an interest in it that will not be resolved. No title is issued until the estate is closed. And you're right, it does take some effort and it takes some.
A whole nother court. Yeah, that's family court, correct?
No, that's criminal court.
Criminal court. Okay. So, that's a whole nother courtroom. So
yes, it is. I'm just warning you.
Yeah, I'm just saying, how can you put abandonment on a kid when the court knows in their eyes that this guy is homeless and we ordered her to leave and she's not.
I don't know any of that for a fact. I heard your testimony.
You said you don't what?
I don't know any of that for a fact. I've heard your testimony that is the situation.
I've been testimonying this to you for about 3 to 4 months now.
Yeah.
For you to
and
say
I've been
that
telling you for 3 to 4 months, you need to be paying support too. I'm painfully aware of all of this. All right. Before we do anything else, I want to hear from this relative or the.
Oh my God, this is crazy.
Sir, if you think my trying to get to the bottom of this is crazy, I'll just go ahead and dismiss your motion for contempt right now.
Just hold it up to your face. He's gonna hear from you.
My understanding understanding of this is that your mother is deceased and that all of you have an interest in this home. Is that correct?
Yes, sir.
Okay, but nobody has gone to probate court to get a legal title to this, have they?
No, sir.
Okay, can you explain why not?
Because it's in the family name. My mother didn't make a will.
It does not, it may be in your mother's name.
It's in my mother's name, I mean. Because she didn't make a will.
Okay, I'm sorry, say it again, please, sir.
It's in my mother's name still, because she didn't make a will.
Okay, well, there's a process under Georgia law when somebody owns property. Just once they're deceased, obviously they can't do a lease. No one else can do a lease because nobody has a legal interest in it until the probate court gives it to the heirs. Y'all need some legal advice on probate matters.
I understand.
So how is it that you plan to give a lease to
I never plan to give a lease.
No, nobody's got the legal right to extend a lease.
Okay. Okay. I'm asking another question. Why is all this stuff happening right now? Who's the cause of everything?
You cause of it.
So I caused.
Okay, don't argue. Remember what I said.
Yeah, I'm not arguing. I'm
yes, you are. Because you gotta, sir. You do not get to respond after each and every answer he gives you. You will get one opportunity to respond to everything both witnesses have said. Do you understand that?
Yes.
Then don't do it again. Go ahead. If you have a question.
Uncle, do you want, so who would you rather want back in the house?
I don't know. Right now, I don't know.
So I haven't been living there since our mother came there.
What?
I haven't been living in that house since my mother came to Georgia. Our mother came to Georgia.
Of course you live here.
So you think it would be right for her? You think it would be right for you to tell me I can't come back to the house that she done left?
I didn't say you can't come back. I said I don't know. Because you'll be able. The man was showing me to the house.
So did I not tell you when
I was with you all this time. And you don't tell me that you never paid the mortgage. Until you tell me you don't care about no house. All you care about is your son. When I ask you why you do that. Come on, man.
So okay, my next question. Do you want Abby out the house so I could come back in the house?
I don't want you back in there. I don't want both of you to my feelings now. Both of you.
So is that your house or
you don't want either one
or our mama house?
Did I understand you to say you don't want either party living in the house?
That's right.
Okay.
How you gonna tell me you don't want me living in the house?
Because you baby your name and throw me out.
So I never told you 2 months ago that I needed to pay on it.
All right, I'm done. Sir, you did it one too many times. I'm moving this hearing till
I said I never told you.
Sir, you interrupted him again and you started arguing again. Action against Ms. Lathan.
Okay.
I can't get in the middle of a family squabble.
Yeah, that's my fault.
Okay, you've done it now. September 6th. I'll see you back then. I cannot speak when you're interrupting me constantly. Okay. Do you understand? You keep saying you understand and then you keep doing it. Okay, you're on mute right now.
You asked me a question and don't want me to respond. You said, do you understand? Yes, I understand. I can't say yes. Now you saying I'm doing too much?
I said you were interrupting the witness, then you were interrupting me while I was talking. You just do not know when to be quiet. And it hurts your case.
So, can I speak now?
Yes.
Like I said, you ask me a question, and then when I respond, you tell me don't say nothing.
You were talking to over the witness.
I just asked you a question. You asked me a question, and then when I respond, you cut me off.
And
how can I respond?
What question do you think that I ask you, other than do you understand about interrupting people?
That was a question. Is that a question? Yes or no?
That's a question. Do you understand that you cannot interrupt people?
And I said yes. Simple. And then you just cut me off and just said a date
because you kept talking while why do we have this problem, sir?
That's what I'm trying to figure out, because you're asking me a question and you want me to respond, but you don't want me to respond. But you're asking a question.
Okay, go ahead and respond. Everything you want to say.
No. I'm just going to say, I'm going to just be quiet. And then when you tell me I can speak, I can just speak. Because when you ask a question, I'm afraid to answer the question before I talk, because you said I'm cutting you off when you're still talking.
Okay, I asked you if you had any more relevant questions of this witness that have something to do with the actual case that is in front of me.
Yes.
That is your motion for contempt.
Yes.
Okay. Make sure it's relevant now. Go ahead.
My next question is, Uncle, how can you want to say, how can you want to put me out of the house because I fell a little behind because I'm going through this?
That's not the reason. You should tell us we're family. Well, you respond to me. You don't give up what not bought the house. All you care about is your son. That hurt. And then you throw me out. Come on, man, please.
So you thought I was gonna pay the house?
Come on, don't even ask me no more questions.
Okay.
Who was that? I know.
Okay. It's a long time, sir, and I can't think of anyone who has tried my patience more than you. Ever. Since 1983. 40 years. And you're at the top. All right. Do you wish to respond? This is your opportunity to respond to what has been said by the petitioner and by the witness. Is there anything else you want to tell me in response to what they have testified to?
Okay.
And make it brief. I got 4 more hearings waiting on you.
First of all, I want to thank you for everybody for my time, going back and forth with you. And I appreciate that. All I'm saying is I need to get back into my house, sir. I understand that my brother, he knowingly knew I was homeless when I left the home, and he gave me his car. That's number one. When he knew I was homeless, the police put me out, he gave me his car. He knew I have nowhere to go. He know I'm going house to house, sleeping couch on couch. And he's at the house every other day with her. My brother doesn't do anything, nor my brother or Miss Pearl. They have jobs, so I don't see why is it she doesn't have working a job to move out the home, so I can get back to my house and I can pay her on the child support. Then she can go find a basic income home to go live at. It's been over like 6-something months. Nothing has been done. It's not like she's trying to find something. She doesn't have a car. Like, how do you expect to do stuff with kids when you don't have a car? My son is not even in school. School is free right now. Whatever she said about school is free. My brother never agreed to no lease. When she said they were having a lease, it was never no lease agreed upon. So I'm just feel like I'm bashing this courtroom right now. Like I just feel like no one's there for me. That's what I feel like. You're coming at me saying that, okay, I know I'm supposed to pay child support, but I'm homeless. I have nowhere to go. Y'all claiming I got all these business stuff. Can y'all prove it? No one is proving anything. It's just a he say, she say. No one is proving actual facts. I don't have I have a business name. Yeah, everybody has an LLC. It's $100. It's nothing to buy LLC. It's $100 in EIN. It's free. So anybody can say they have a business. I don't have no business properties in my name. I don't have anything right now. I'm homeless. I'm trying to get back home where I can be. My mother, it just breaks my heart that a single woman can't even like do it. She's not and do what she needs to do to make it seem like she has nobody. Because at the end of the day, she's pleading a victim role, saying she has no help when my brother and girlfriend's there each and every day.
Okay, so you expect her to work, but not yourself.
What do you mean? I'm gonna work too.
Well, you're not working.
I expect her to leave the home so I can get back to my daily living standards.
What does that have to do with you working?
Being in the right area to get to work, getting back and forth to work, taking a bath each and every day, having the right proper clothes, having all your right material stuff when you go to work. Because going to work and you live in a home and you do the same thing every single day, when it changed, how do you expect somebody to do something?
Okay. All right. Anything else, sir?
I'm asking the court just to allow me to come back home, and you're issuing her to leave the house, and no marshal has been sent out, no nothing. And I just feel like this is, I'm feeling bashed in the courtroom. I feel like it's another. You said what?
Else? Yeah, you're repeating yourself.
I feel like I'm bashed in the courtroom, and there's like no help for me right now.
Okay. All right, ma'am. Do you wish to make a final argument as to whether you're in contempt of court? You need to unmute. You need.
Are paying child support on May 1st. May 1st comes before May 31st. So he's completely giving me all responsibility of his child. He expects me to fund somebody watching him, move out at the top of the hat and be able to work. He hasn't even, it's just no of him following either. He's not even trying to follow the court order, which I am trying to move out. Do I want to live here long term? No, I don't. But it's certain things that needs to be done so I can move out. Okay, he making this argument, he's homeless, but you're willing to put your own son
court. And I'm going to issue an order for the sheriff to remove you by September the 16th.
Okay.
So you've got a month. The court has tried to connect you with multiple resources available for shelter. I'm sorry, but as far as making the respondent do what he was required to do, you have to file a contempt action. I can't hear that.
I actually did, but
okay, but he hadn't been served. Well, when he moves back in the house, they'll know where to serve him.
Mm-hmm.
And that's all I can say. Both of you need legal advice. He has no ownership interest in that house at this moment. He may at some point, if they will properly file in probate court for the home and property of their mother to be distributed according to law. But nobody's bothered to do that either. So, sir, and I'll go ahead and tell you, if she files a contempt and you haven't paid, then the sheriff will probably be coming to get you. You got to do more than you're doing. You'll have no excuse. and she can go file for an abandonment warrant whenever she wants to. So that will conclude the case. I'm sorry that both of you have had to go through this, but in some ways it's your own fault, both of you. I don't find the respondent's testimony to be all that credible with regard to his alleged inability to work. However, that's what will come back to haunt him if any other further legal actions are filed on behalf of the child in terms of getting child support, whether it's filed through the criminal courts or filed through a contempt action in this court.